there. No bail for the riot conspirators. That is the big breaking update coming in as far as when it comes to this entire almost over 20 minutes that we're looking at of this judgment that is now being pronounced by the Supreme Court. Let's quickly get an understanding from Bhavtosh, who is connected with us. Bhavtosh, what has just happened in the court there pronouncing the verdict?
Amitabh, very big order from the Supreme Court. So even after 5 years, Umar Khalid and Sharjeel Imam have not got bail in the larger conspiracy of Delhi riots. The Supreme Court had made it very clear that they have in fact dissected the role of each accused in this case. We have not got the full order of the Supreme Court, but it has said that Umar Khalid and Sharjeel Imam stands on a different footing as far as other accused in this case. Their role are different, so they are in fact part of a larger conspiracy. It's a very big setback for Umar Khalid and Sharjeel Imam. But having said that, the prosecution has managed to prove its case against Umar Khalid and Sharjeel Imam. It means that the prosecution case that they were in fact part of a larger conspiracy. They wanted a regime change, and also that they wanted to carry out riots just before Donald Trump's visit in Delhi, and they wanted to project the CA, Citizen Amendment Act, as an attempt to show that there is a pogrom against Muslims. All those points have been upheld by the Supreme Court. In fact, Supreme Court has said that they are looking at the possibility of role of each accused in this case differently, rather than clubbing all the roles together, has been upheld by the Supreme Court. Supreme Court has said no bail to Umar Khalid and Sharjeel Imam, and it's a very big news. And what has happened as far as the case is concerned.
What about the other accused in the case? The judgment on the other accused in the case, Bhavtosh?
Well, what the Supreme Court has said as of now, that full order has not come out. Bail granted to following accused: Gulfisha Fatima, Mehran Haider, Shifa-ur-Rahman, Mohammad Salim Khan, Shaddab Ahmed. So other accused in this case, 5 accused in this case have managed to get bail, but 2 accused, the main accused as far as this entire case is concerned, there were 7 accused in this case who had asked for bail. So 5 accused have managed to get bail, but 2 other accused in this case. The main accused in this case, Umar Khalid and Sharjeel Imam, had not got bail. Gulfisha and Fatima,
so out of the 7 accused that we are looking at, 5 of them have managed to get bail from the Supreme Court. This verdict that has just been announced, and more importantly on the grounds in which that this bail has been rejected by the Supreme Court, that needs to be taken note of, saying that on completion of the examination of the protected witnesses and the completion of 1 year from this order, appellants may be at liberty to move for an application for grant of bail. But this court is satisfied that the prosecution material disclosed prima facie allegation against the appellants of Umar Khalid and Sharjeel Imam, and the statutory threshold stands attracted qua these appellants, and this stage of proceedings do not justify enlargement of bail. This is on the grounds that we are looking at as far as the bail that has now been denied, in particular to Umar Khalid and Sharjeel Imam. The rest 5 of the accused have managed to have been given bail that has been granted by the Supreme Court. Straight away connecting with Mohind on this, he is there with the victims' family of Delhi riots 2020. क्या राहत की सांस आप वो लेंगे? कम से कम उमर खालिद और शर्जील इमाम को मोहित बेल नहीं मिली है.
Well, yes, in fact, Amita, we know for a fact that how Sharjeel Imam and Umar Khalid have not been granted bail. The court said that prima facie there are evidences against them that they were part of the larger conspiracy, but other 5 accused have been got the bail. Let's speak to the victim's father over here. Rahul Solanki was killed. He was shot dead during the Delhi riots, and shortly from now we will hear from his father that what exactly he has to say on the verdict, because they have been waiting here since morning. They were saying that the verdict should favor them, not the accused, and now we'll try to speak to him that what exactly he has to say. So we have Hari Singh Solanki with us, father of Rahul Solanki, who was shot dead during the Delhi riots. He was a 26-year-old young man. Sir, सुप्रीम कोर्ट ने एक बड़ा फैसला दिया, शर्जील इमाम और उमर खालिद को बेल नहीं दी और कहा है कि उनका कहीं ना कहीं एक लार्जर कॉन्स्पिरेसी में रोल था। बाकी जो 5 एक्यूज हैं उनको बेल दे दी गई है। कैसे देखते हैं, क्योंकि उमर खालिद और शर्जील इमाम की बात करें तो इस पर राजनीति भी हुई, कई जगह से कई प्रेशर भी आए, लेकिन अब जो है 2 लोगों को बेल नहीं मिली है। सुप्रीम कोर्ट ने ये कहा है, क्या कहेंगे?
2 लोगों को जो बेल नहीं दी है उसके लिए माननीय सुप्रीम कोर्ट का शुक्रिया अदा करना चाहेंगे, लेकिन 5 लोगों को बेल दी है, एक दुर्भाग्यपूर्ण है। क्यों कि पीड़ित सनातनी जिनके 15 बच्चे मारे गए हैं, बेटे भाई, वो हमारे अपने ही हैं और उनकी जान के लिए खतरा बना हुआ है और उनके लिए सुरक्षा मुहैया कराना आवश्यक है। मैं सुप्रीम कोर्ट से ये प्रार्थना करना चाहूंगा, भारत सरकार से प्रार्थना करना चाहूंगा, गृह मंत्री जी से प्रार्थना करना चाहूंगा, सुरक्षा मुहैया कराई जाए, अन्यथा अनहोनी होने की संभावना बनी हुई है।
आपका बेटा एक 26 साल का युवक था जो जॉब करता था, दूध लेने गया था, उसको गोली मार दी गई। आपका जो दुख है एक बहुत बड़ा दुख है, कहीं ना कहीं न्याय की आपको उम्मीद थी। तो सुप्रीम कोर्ट का जो फैसला है, अगर उमर खालिद शर्जील इमाम की बात करें तो ज्यादा फोकस में वो थे जब से केस चला है। उनकी स्पीचों के बारे में भी काफी सवाल उठे थे जो उन्होंने स्पीच दी। अब उन दोनों को बेल नहीं मिली है, 5 को बेल मिली है। कैसे याद करते हैं उस दिन को और आज क्या कहना चाहेंगे सुप्रीम कोर्ट से और देश की जनता से जो इस समय आपको टाइम्स नाउ पे देख रही है?
मैं सुप्रीम कोर्ट से ये कहना चाहूंगा कि 5 लोगों को जो बेल दी है ये दुर्भाग्यपूर्ण है और सनातन का आगे खात्मा करने का शायद सुप्रीम कोर्ट ने निर्णय लिया हुआ है। मैं भारत के सनातनियों से अनुरोध करना चाहूंगा, सुप्रीम कोर्ट के लिए एक आवाज उठाई जाए कि सनातन को सुप्रीम कोर्ट इस तरह से खत्म करेंगे, वो दुर्भाग्यपूर्ण होगा। तो इससे हमें लगता है
न्याय की उम्मीद अभी भी है कि आपके बेटे को, राहुल को जो है न्याय मिलेगा पूरी तरह से, क्योंकि अभी जो उसके केस के अक्यूज हैं उनका भी केस चल रहा है।
हमें तो पूरी उम्मीद है, हम तो यही सुप्रीम कोर्ट से उम्मीद करेंगे। इसी तरह से 2 लोगों को बेल नहीं दी गई है, चाहे इनको बेल दी गई है, हम चाहेंगे इनको बड़ी से बड़ी सजा दी जाए और मौत की सजा देना बहुत जरूरी है।
एक और सवाल आपसे पूछेंगे, क्योंकि आप यहाँ पे थे उस समय, आपने पूरा माहौल भी देखा था। एक लार्जर कॉन्स्पिरेसी की बात हुई है कि सब कुछ प्री प्लान था। आपको लगता है कि प्री प्लान था? उसमें उमर खालिद और शर्जील इमाम की बात होती है, आपको लगता है एक प्री प्लान था, पहले से ही ये दंगे की साजिश की गई थी जिसमें आपने अपने बेटे को खोया?
देखो जी, ये इसमें प्री प्लान महीनों पहले से चल रही थी, वो हमने देखा, लेकिन हमको ऐसा नहीं लग रहा था कि ये ऐसा करेंगे। जैसे कि राजधानी स्कूल है जिसमें महीनों पहले से इधर उधर ट्रैक्टरों से ईंटें उतरती थी और रात में ले जाया करते थे, हम निर्माण कर लेंगे, हमें क्या मतलब है। लेकिन
छतों पे ईंटें थी, आप ये तो कहेंगे कि छतों पे ईंटें हमने भी देखी थी, मैंने उस टाइम खुद कवर किया था। छतों पे ईंटें थी, बोतलें थी जो कि दंगों में इस्तेमाल की गई। तो प्री प्लान तो कहीं ना कहीं था। ये
प्री प्लान तो था, तेजाब का भी यूज किया गया, पेट्रोल बम का भी यूज किया गया। ये खुला पेट्रोल जो मिलता है, इससे सनातनियों को खतरा है और सनातनी किसी के लिए खतरा नहीं, सनातनी ही सत्य है, सत्य में।
आज के फैसले के बाद और उम्मीद बची है?
आज के फैसले के बाद ये उम्मीद करेंगे कि भाई इन लोगों को जो बेल दी गई है,
as far as of the riot victims, that they are happy as far as and relieved on part of the Supreme Court denying bail to the main accused here in the case, but the other 5 in the case who have been granted bail, conditions on their bail has also been applied by the Supreme Court. So Bhavtosh, for a better understanding that is now coming in, as far as prima facie allegations against Umar Khalid and Sharjeel Imam has now been proved by the prosecution.
Yes, what the Supreme Court has said is the prima facie allegation against Umar Khalid and Sharjeel Imam has been proved. What are those allegations? First is Sharjeel Imam, who in fact made a speech in outside Aligarh Muslim University, where he said that if there are protests that are carried out at the Chicken Neck, which is in fact on the border town connecting the mainland with Northeast, if those protests are carried out, then India Northeast will be cut from the mainland, and then it was series of protests that were carried out outside Shaheen Bagh. What are the main allegation against Umar Khalid? It is his speech that were carried out, were made just a week before Delhi riots, and also various WhatsApp groups that were made by Sharjeel Imam as well as by Umar Khalid. What the prosecution has said is that there was a deeper conspiracy or the larger conspiracy that were made by Sharjeel Imam as well as against also by Umar Khalid, where they in fact tried to project both Citizen Amendment Act as well as NRC as as medium in which Muslims have been targeted. First, they wanted to carry out protests in localized area. That did not happen, and then protests were carried out at various places. Now, in the affidavit that has been submitted in the Supreme Court, they have said that one should not only look at the riots that broke out in Delhi, but also the protests that broke out in UP as well as in Assam, in which there were a large number of people that were killed and also violence that broke out. So they have said that while they have been charge sheeted in the Delhi riot case, but also the larger role that they had played out in various riots that broke out at different places. Now, those are the allegations, or at least those are the roles that they had played out. Now, Supreme Court has made a very big observation. They have said prima facie their role have been established. Now, Supreme Court has also said that the trial in this case should be completed, so it could be possible that charges against them will be framed. Other accused in this case, 5 other accused in this case, have been released on bail.
That was standing in solidarity with the likes of Umar Khalid and Sharjeel Imam. Now have they got an answer coming in from the courts of the country where certain interference that it amounted to even undermining the judicial system here in the country, have they now been given the answer by the apex court of the country? Let's get in a word from Mr. Khaliqur Rahman as well. What do you make of this judgment, sir? Clearly, when it comes to the role of the accused here has been defined. The conspiracy is the same when it comes to the role that they have been played by these individuals. 7 of them, 5 of them managing to be granted bail on conditions that have been given by the Supreme Court. 2 of them did not, because the prosecution in a way has proved their role when it comes to the Delhi riots conspiracy, sir.
Yeah, good morning. In fact, because we, as the law-abiding citizen, we all respect the verdict of the Supreme Court, but still, there are arguments which needs to be done, because when it comes to establishing the prosecution and also the conspiracy against conspiracy by the Sharjeel Imam and Umar Khalid, because there was no trial actually happened, and for the last 5 years there was no prosecution and no charges were framed, and in the absence of any charges being framed, and the prosecution has happened in this last 5 years, so the Supreme Court coming to the conclusion that these 2, the Umar Khalid and Sharjeel Imam, involvement as the main conspirators, I think that is something which probably, the lawyer of Umar Khalid and Sharjeel Imam would be arguing again, making an appeal against this.
Thought, sir, Mr. Lalit Ambedkar, because the prosecution has alleged that Umar Khalid was part of a larger conspiracy to incite or to plan violence. He's been charged under multiple sections of the UAP, along with provisions related to writing, unlawful assembly, promoting enmity between groups, and other offences linked to the riots.
See, the argument given, discussed earlier also was that one of the arguments that must be given in the court as well, that they were not personally involved in a present during the riots. Listen, Osama bin Laden did not directly hit the World Trade Center. Taliban did not actively participate in 9/11, and yet Afghanistan was bombed to almost Stone Age by Americans. Similarly, in these people also, they were protesting. What were they doing? It was not an ordinary civil protest. It was an attempt to incite the Muslims of rest of India against CIA. CIA was what? To grant right to life and dignity to Hindus and Sikhs that Nehru and Congress had abandoned to Pakistani Islamist post-British partition, knowing well that Pakistan was created only by the Muslims of then India and for Muslims alone. And their persecution, genocidal persecution, continues till date. Look at what's happening in Bangladesh. Look at what's happening in Pakistan. 24% population 1947 is reduced to 2% in Pakistan, and from 16% to 7% in Bangladesh. And these people were inciting Muslims against this humanitarian act. I think they should rot in jail. What the Supreme Court has done, they have granted bail. On what grounds? They are the ringleaders. They are the collaborators. Collaborators of all this conspiracy. They held Delhi to ransom against CAA. Brought the old people, children onto the streets. India was on the verge of civil war. And these people, I think, what court should have done, denied bail to others as well. But ordered speedy trial. And that should set an example
by the
for
courts,
those.
Mr. Amridar, as far as speedy trial in the case is concerned, but the role of these two individuals in particular. Aditya, what is your understanding? Because we have seen the Solidarity lobby also standing there firm that they must be getting bail because the trial in the case hasn't started. But the Supreme Court has gone in lengths, especially when it comes to defining the role of each of the accused, especially when it says that prima facie, when we speak of the allegation against Umar Khalid and Sharjeel Imam, they completely stand on a different footing.
Well, of course, if that is the opinion of the Supreme Court, then of course that has to be respected, because ultimately, you know, the Supreme Court probably would have, like, even though it may not figure the judgment, but the Supreme Court would have taken notice of a lot of contemporary developments that have happened around the world. For instance, you know, like as we were discussing earlier, Section 15 of the Unlawful Activities Prevention Act defines the offense of terrorism. And it's a very clear offense of a definition of terrorism which has been given. And all the variety of acts which constituted, using weapons, non-weapons, all of the things, they all get covered within the act. Now, the Honorable Supreme Court, applying the rules of statutory interpretation, Supreme Court has to give a purposive interpretation to Section 15. The question of reinterpreting or redefining it does not arise. Section 15 appears to be a well-drafted section. It contains all the details. And therefore, the Honorable Supreme Court, when it interprets Section 15, it has to adopt it has to first grammatically interpret the section, and number two, interpret in a manner which will further the objects, not reverse them. Secondly, what happens is the Supreme Court probably appears to have come to an opinion that the riots which happened in Delhi, they were probably, they were not a regular riots in the sense of the word, because on one hand, you have the regular riots which happen, some issue arises, it's localized. But if, let's suppose riots are happening in multiple places, or rather, because what happens is that, what the Honorable Supreme Court probably has opined is that if you look at the last 1 year, so many civil unrests happened which actually led to regime changes happening. Look at Bangladesh, look at Nepal.
Correct.
So one can understand that the Supreme Court might perhaps come to an opinion that that these two individuals, they stand on a separate footing vis-a-vis all the rioters. Because see, when a criminal riot happens, there's an
would there be individuals there sitting across the border and rather far from the border still say that we are thinking of you, Umar Khalid? Because now here, when it comes to initially the arguments that were placed in court, as Harish is also connected with us right now, the Delhi police had initially opposed their bail plea, saying that the riots were not spontaneous, but were orchestrated, pre-planned and well-designed attack on India's sovereignty. And that seems to have been, as far as prima facie, the allegation that was proven in the courts. And this is something that has been accepted by the Supreme Court. Swapnil, just coming to you, let me just take a quick live update from Harish as well. Harish, the Supreme Court has decided conditional bail for the 5 other accused, but Umar and Sharjeel Imam have been denied bail.
Yes, that's right, Amita. As far as the operative portion which was dictated in the court is concerned, the most important portion being Justice Arvind Kumar stating that the prosecution has prima facie established the allegations against Umar Khalid and Sharjeel Imam. And what was the allegations? That the act they indulged in was not mere protest or routine riot, but something orchestrated aimed at a regime change. This is what the Delhi police had said, and that is to destabilize India's internal harmony and international standing. The Delhi police had also said that they wanted to turn the anti-CAA protest into a national protest and to disturb communal harmony and to endanger India's unity, sovereignty and security. And the Delhi police, remember, had very significantly played inflammatory speeches made by Umar Khalid and Sharjeel Imam. The videos were unprecedentedly played by the Delhi police before the Supreme Court bench, vociferously arguing that Umar Khalid and Sharjeel Imam should not be granted bail. So the Supreme Court, prima facie, finding merit in these arguments, also take into consideration that the charges against them is under UAPA and under Section 15 of the UAPA defines Terrorist Act, and prima facie what they did in the East Terrorist Act, this is what Supreme Court has concluded, because that had led to that inflammatory speeches made by Umar Khalid and Sharjeel Imam had led to communal violence, which had claimed 53 lives and left more than 100 injured.
All right. Well, quick update, Swapnil, from you, then Mr. Lalit Ambardar, because here when we speak of culpability, that has now been defined by the Supreme Court, because the record discloses that all of the appellants do not stand on equal footings, and the hierarchy of participation that requires the court to assess each application individually.
Right, Amita. Now, we've discussed the observations, we've discussed the judgment, we've discussed why 2 people were denied bail and why the rest of them were granted bail. Now, for the benefit of your viewers, I would just like to tell you what lies ahead. Is that very simple, that people who've been denied bail can apply after maybe a year or so, because that is what the Supreme Court has said, that you can apply for the apply for the bail. Now, what happens at that time, I do not want to speculate on that, because then the Supreme Court might once again say that, look, the trial has already started and I don't think you should apply for bail, etc., etc. The other thing is that the people who've got the bail, the prosecution can apply for the cancellation of their bail, but albeit after 6 months or 8 months, because they need to have some more evidence at their hand to try to convince the court that, look, even these 5 needed to go behind bars, but you have let them off. And meanwhile, the prosecution has to pull up its socks and try to ensure that the speedy trial takes place, because if the trial does not take place, it goes at the very heart of Article 21. So the Supreme Court, so the prosecution has to remember that Article 21 is a fundamental right, and that overarches every single provision of whether it's the BNS or the UAPA. Now, that being said, my point is very clear, Amita, that what has happened today will set the bar, will set the role, and I believe that when this trial actually takes place, I see at least 2 or 3 of them trying to get the gallows, if not a full life imprisonment. So I believe that this is what the benchmark needs to be. The Supreme Court needs to heighten its level of punishment. And that is where it's very important.
Right. Mr. Ambardar, what is your understanding as far as when it comes to the, we are trying to access the full copy of the judgment here as well, but also coming in from the Supreme Court that multiple conditions that have been applied on the bail application to the other 5 accused, and if they violate any, their bail automatically would be cancelled. This is coming in from the Supreme Court of the country. Yes, sir. What is your opinion?
See, India is the worst victim of pan-Islamism, inspired supremacy and incompatibility. We suffer genocide. On this account only Jinnah was what these Sharjeel Imam today is speaking about, or Khalid is speaking about. This is what Jinnah said, which led to the bloody partition of India. We can't afford to let these people flourish in India anymore, because we can't afford any more partitions in India. Number 2, Hindu lives must matter in India. It must. It's just today's judgment from the court. Though party, I don't agree with releasing, granting bail to the rest of the guys who are part of the team, who are part of the ringleader team, and they are the collaborators. Look, Yasin Malik is not being tried for he is not serving charges for genocide of Kashmiri Hindus. He is being tried for terror funding. Similarly, not one rapist, mass murder involved in Kashmiri Hindu genocide has ever been convicted, or not even trial has happened. So justice must prevail in India, especially regarding the communal violence which is targeting Hindus, so as to set a deterrent. And I think if this trial commences fast, as has been ordered, as you're informing that the court has ordered about the trial should be expedited, I think you should set a deterrent. No more Khalid Umars or Khalids or these people should be allowed.
Question to Mr. Khaliqur Rahman then. Would it serve as a deterrent, sir? Because as far as this entire verdict is concerned, where the role that has been characterized as grave and indicative of coordinated conspiracy behind 2020 riots that killed over 50 people in the national capital, would it now set an example, sir?
Since the Supreme Court today, in fact, has taken this decision and given the verdict based on the prima facie allegation. So what the word you need to understand is
which
it is
has been
allegation.
It is by
not,
the prosecution. So complete line.
That's but in fact, still, because there has not been trial in this case, the trial is yet to start, and during the course of the trial, what evidence and what material is going to come in, that in fact needs to be looked into actually. So I think it is too early for anyone to jump into conclusion that these two, the Umar Khalid or Sharjeel Imams, the actual role, in 2020 riots, to what extent they were involved.
I think we're getting a live reaction from the Supreme Court itself, but in the meantime, the role here that has been played by the two individuals, Aditya, for the better understanding for our viewers as well as what Mr. Khaliqur Rahman seems to be implying here, because the role is something that on a completely different footing is something that the Supreme Court has admitted. As far as both of them, they have played. Not being there physically present, but the way that the riots have been incited, what has been as far as when you see the standing of these two individuals are concerned, and how do you see the case progressing from here on?
I think given the light and wording of the Supreme Court order, I believe that now it will not serve any purpose for Mr. Umar Khalid and the other the other person to file fresh bail applications now, because obviously one cannot keep filing bail applications repeatedly. As Mr. Kothari said, there has to be some difference of time, and thereafter there has to be some new ground on the basis of which. So what I also feel now is that even the learned judge in the trial court should put his foot down, because see, irrespective of what proceedings are going on in High Court and the Supreme Court, it is the onus and duty of the trial court to ensure that the trial proceeds. Because I'm telling you, like every time, also all the High Court and Supreme Court say that we do not impose any fetters on the learned trial court. Now the trial court should take this as an opportunity to proceed ahead with the trial, and to the contrary, those people who do not want the trial, who are trying to delay the trial court should pass strictures against them. In fact, I would also call upon the honorable trial court to actually invoke all the remedies provided to it under the CRPC to invoke all its necessary powers to ensure that the trial proceeds without delay. In fact, one will have to examine the case record and see what has caused, how many adjournment applications have been filed, who has moved the adjournment application. Trial court should act strong. It should impose heavy costs on those who are seeking unnecessary adjournments. Today, before the Honorable Supreme Court, the question is, trial has not begun, whether to grant bail or not. Now, if you look at the wording of Section 15 of the Section 15 of the UAPA Act, gives a very wide meaning to the act of terrorism. So, and not only is this a wide meaning, but it is also designed to ensure people at all levels of the hierarchy come within its scope and ambit.
So does criminal conspiracy under UAPA, Swapnil still stands here in this case as what has been defined by the Supreme Court, because it has noted the special nature of the UAPA, which deals with these sensitive cases amounting to sovereignty and national security?
Well, absolutely. I mean, if there are 7 people or 8 people who've acted on different aspects of a particular riot, that means there has to be conspiracy. Conspiracy, simply put, for the benefit of viewers, means meeting of minds. So there is no question that conspiracy is an essential aspect of, not only BNS, but also under UAPA. Now, if there was just one person who acted on his own, just deciding one finding that, okay, I know how to make a bomb and let me blast it. That is a very, very, very unique act which hardly ever takes place in issues of this kind, where you protest against CA and things like that. So there has to be several people up the ladder whom we do not even know. These are people who are there before the court, Amita, who are there, who have been charged. There could be several people who could be there behind this. This does not end just with these 6-7 people. There has to be a chain up the ladder somewhere, where people decide these things, devise these things. So these kind of things do not take place without some masterminds.
But the court has also said, Swapnil, when there is a delay in trial, that is invoked in stringent laws of the UAPA, then what should the court do?
The court should order expedited trial. It's very simple. That's all you need to do. You just can't twiddle your thumbs and say that, okay, pass judgments and things like that. But you have to pass an order for expedited trial, which I believe the court has done.
All right. Harish, coming back to you on that, as far as the other accused in the case is concerned, on the grounds that they have been granted bail and on the conditions as well that has now been applicable, if they violate any, immediately their grant of bail would be dismissed.
Yes, that's right, Amita. Though Umar Khalid and Sharjeel Imam, who had been projected as the main accused by the Delhi police itself, apart from these two, among the 7 accused, as you rightly said, Amita, Gulfisha Fatima, Miran Haider, Shaifur Rahman, Mohammad Salim Khan, Shabad Ahmed, these 5 have been granted bail, wherein Supreme Court has very clearly said that role played by each accused shall be seen as staggered, and the Supreme Court said that it had gone into the allegations level by the Delhi police against each of the accused, and said that Umar Khalid and Sharjeel Imam had played a more important role, and prosecution has established the fact that their act had endangered India's unity, sovereignty, integrity, and remember the prosecution had even argued that what they had done was an attempt at a regime change and trying attempt to spread communal discord across the country, and even their inflammatory speeches were played as per records in the Supreme Court during the bail hearing. And among the conditions imposed, our Supreme Court has said that trial must be completed immediately, as early as possible, and also regarding these 5 accused who had been given bail, if they violate the bail conditions listed in the detailed judgment, the Delhi police has been given liberty to approach the court for cancellation of the bail. And there is also interesting facet as far as the Umar Khalid and Sharjeel Imam is concerned. Supreme Court has said that they cannot apply for a fresh bail for at least 1 year or till the deposition of protected witnesses in this case is over. So the Supreme Court going into the role played by each accused differently and not taking it as a batch matter wherein in one go all the 7 has been granted bail or denied bail. The Supreme Court has very importantly gone into the role played by each accused. Even the Delhi police had said during the argument that Sharjeel Imam and Umar Khalid stood on a different footing, and they had done several acts, and so endangering India's unity, integrity, and they had said that their act
has been able to prove in court, and the court itself has taken note of that while denying as far as bail to Sharjeel Imam and Umar Khalid. However, the rest of the 5 accused in the case have been granted bail with conditions. But more reactions that have been coming in as we play out through and understand the observations mainly that has been made by the Supreme Court of India. Let's put out some political reactions as well.
भारत के टुकड़े करने का सपना देखने वाले इस पर जो न्यायालय ने फैसला लिया है, ये स्वागत योग्य है। देश की एकता, अखंडता, देश की प्रभुसत्ता से ऊपर कुछ नहीं, और नेशन फर्स्ट, इस पर देश को चलना चाहिए। स्वागत योग्य फैसला है। जो देश को तोड़ना चाहते हैं, जो भारत तेरे टुकड़े होंगे और चिकन नेक से तोड़ देंगे, इसकी षड्यंत्र बुनते हैं, योजनाएं बनाते हैं, मकड़ जाल क्रिएट करते हैं, उनकी जगह जेल में है, बेल में नहीं।
देखिए, जो भी उच्चतम न्यायालय ने फैसला किया है, रिकॉर्ड के आधार पर फैसला किया है। उन्होंने बाकियों को बेल दी है, इन दोनों को बेल नहीं दी। तो मुझको लगता है कि कुछ ना कुछ रिकॉर्ड में ऐसा होगा जो इनका केस दूसरों से जुदा लगता है। मगर आज देश भर में जो उम्मीद थी कि इनको बेल मिलेगी, आज कई लोग इससे नाखुश होंगे, क्योंकि जो संविधान की आस्था है वो फ्रीडम में है और लिबर्टी में है। इतना लंबे अरसे के बाद बेल ना मिलना, इससे एक चिंता का वातावरण तो पैदा होता है।
सर, ललित अंबरदार, ये जो बेल इज एन, जिसको कहते हैं एक्सेप्शन है, और इसको किस तरीके से डालना चाहिए, इसको किस तरह से इन्वोक करना चाहिए? सर, ये सारे राइट्स ऑफ लिबर्टी एंड फंडामेंटल राइट्स उस वक्त क्यों याद आते हैं, स्पेशली ऑन द इंडिविजुअल्स हु हैव बीन चार्ज्ड विद UAPA?
Very rightly pointed out by you. See, जब शर्जील इमाम कहता है कि कश्मीर चिकन नेक में रहने वाले मुसलमानों को कहता है कि you rise against the nation, choke chicken neck, so the northeast of India is cut off. Can you imagine? And just remember, Sharjeel Imam, all these 7 people, they're not ordinary Indian Muslims. They have a huge following. And the way they were propagating, the way they were trying to mobilize the masses, Muslims against the Indian state, you have to, that's a major consideration. And क्या उस वक्त उसके बारे में ये क्या चुप रहे? आज उनके लिए sympathize कर रहे हैं उस अंकित शर्मा, I think that IB officer who was stabbed. Can you imagine, as per the forensic sciences, one stab is enough to kill a man. That guy was stabbed couple of dozen times. That showed hatred. A killed man is stabbed again and again only because of hatred towards Hindus. And I think should they deserve sympathy? And bail is a procedure. Bail is a procedure unless until they say even try to question the authority of the law to grant or to deny a bail. I think that's going to be too much, because the apologists all the way went to America to plead for, the parents of these people went all the way to America to plead for justice.
Concerted efforts have been made. Concerted efforts have been made by a certain lobby there, sitting within the country and outside the country as well. But Mr. Khaliqur Rahman, that seems to be the note that has come in from the Supreme Court, because UAPA as a special statute that represents legislative judgment as far as the conditions on which bail may be granted in pre-trial stage. Now it is up to, as far as the lawyers here are concerned, of these 2 individuals, which will see that on what grounds will they seek bail for Umar Khalid and Sharjeel Imam.
Yeah, it's because so based on the allegations, the Supreme Court, in fact, has not granted the bail to these guys, Sharjeel Imam and Umar Khalid.
Reactions are coming in, Mr. Rahman. I'll just come back to you. Let's play them out.
जो आतंकवाद, यूएपीए और दिल्ली को जलाने के आरोप थे वो सही थे। इससे स्पष्ट होता है कि जो दिल्ली में दंगे हुए वो संयोग नहीं, ये सोचा समझा प्रयोग और उद्योग था। ये ऑर्गेनिक नहीं, ऑर्गेनाइज था। ये स्पॉन्टेनियस नहीं, स्पॉन्सर्ड था। और सत्ता परिवर्तन के लिए हिंदुओं को टारगेट करने के लिए किया गया था षड्यंत्र। परंतु कांग्रेस पार्टी ने और उसके इकोसिस्टम ने शर्जील और उमर खालिद को मानो नेल्सन मंडेला बता दिया था। वो उमर खालिद के लिए रोते थे, शर्जील इमाम जो चिकन नेक काटना चाहता था उसके लिए रोते थे। आज कांग्रेस के इकोसिस्टम को बताना चाहिए, कांग्रेस का हाथ हमेशा टुकड़े टुकड़े करने वाली गैंग के साथ, चाहे अफजल हो, याकूब हो, बाटला हो, उसके एनकाउंटर के टेररिस्ट हो, या उमर और शर्जील हो, या नक्सली हो, कांग्रेस पार्टी को आज नाक रगड़कर माफी मांगनी चाहिए।
Rahman ji, would you want to respond to that as far as the statement coming in from the BJP side?
In fact, the BJP, in fact, tries to take everything to the next level and try to bring in the politics there. So I think when it comes to the national interest and the integrity of the country, we are all united actually. So why the BJP thinks always and tries to politicize the thing. So there is no politics here in this. And there we have the Supreme Court. And we, in fact, have the complete trust in the Supreme Court's verdict, Supreme Court's proceedings.
When there was complete trust in the Supreme Court, sir, then why were there attempts made to undermine the judiciary, sir?
No, that's what I'm
Who are these US lawmakers who seem to be writing here and seeking that they must be granted bail on what grounds, sir? Who are the other individuals who are writing letters, handwritten notes to say that we are thinking of you, Umar Khalid? Who are these individuals and what role do they have to play as far as does it not amount to interference, sir?
See, because that is another aspect which in fact needs to be discussed separately. But today we are talking about the Supreme Court's, verdict and the bail petition which was moved actually. And in the last 5 years, in fact, because I think number one, there was inordinate delay in the trial. The trial should have started.
Well, that is now the direction has come in from the Supreme Court, sir. But as far as the 7 accused in the case is concerned, the judgment that was reserved back on the 10th of December 2025, today has been day on the first working Monday of this year. Bail to Sharjeel Imam, Umar Khalid has now been denied by the Supreme Court of India. This is going to be the biggest story that we are going to track, with political reactions also coming in. And of course, the first-hand update that we are getting also from the victims of Delhi riots, with over 50 people were killed in Northeast Delhi back in 2020. We'll continue to get you the ground reports back after the show.